Our commentator will be Larry Alexander, who is the Warren Distinguished Professor of Law at the University of San Diego School of Law. Please join me in welcoming Professor Husak.
Thank you. It's wonderful to be here, of course. I'm down to my T-shirt, and I know what you're thinking. You're thinking, those drugs are really working for Doug. Maybe they'll work for me too, but it doesn't work that way. Okay, a few apologies. I've got a really bad cold, and my voice is not up to its usual, and I apologize for that. No control. Also, I'm going to have to read a paper, which I know is rather dull, and I apologize for that. Thirdly, some of you are really going to hate this paper, and I don't know if I apologize for that. We'll see. So since it's a fairly short paper, and Larry thinks he needs only a page or two to demolish what I'm doing. So I just wanted to comment on one thing that occurred to me in writing this paper. It reminded me of my first days ever getting interested in criminal law theory. I was doing moral philosophy at Rutgers, and my very first sabbatical was at the University of Pittsburgh, and my brother would take me into work every day and drop me off, and I would go to the law school and spend the day in the library, and then he would pick me up. And I decided that I would read criminal law textbooks, and I did. I worked my way through 3 or 4 or 5 textbooks, and I thought, what crap. I mean, really, I thought, I could do better than this. And that's kind of how one of the ways I got interested is thinking, whenever you read what is out there and you think you could do better, that's one way of getting interested in a topic. And so I kind of returned to some of those textbooks here. And interestingly enough, we've got a lot of people here who are primarily philosophers and know a little law, and then we got primarily people who work in law and know actually quite a bit of philosophy. And in my experience, the philosophers tend to be, better and more rigorous, and that's almost always true. I think in this particular case, this particular issue, there's a lot more than usual to learn from the people who have thought about these topics in the way criminal law theorists do. And so I really encourage the moral philosophers here to look at what has been done by people who work primarily in criminal law theory. Okay, so I want to begin with just a simple example that I follow by an argument, and the argument is unsound. I mean, it's obviously unsound. I'm not in any way contesting that. What's not obvious is what's wrong with it. And so I think that if we can identify the defect in this argument, then we will have a better way of appreciating and answering questions about omissions in which we're all interested. We'll be able to, first of all, decide what they are, and I know that's been something that some of you have written about, whether it and to what extent it's morally relevant. And if we're not sure what particular examples are instances of omissions, then we're likely to spin our wheels in thinking about omissions and answering or inability to answer the questions that presumably are the normative issues that interest so many of us. So my claim is that we can't make much progress unless we're at least a little more clear about what omissions are. And I'm hardly the first philosopher to make that point, but I hope to do so in a way that's somewhat challenging. Okay, so what I'm going to call the argument that's on your handout responds to the very simple example, and I just call this Susan's case, everyday case. Susan's driving reasonably along a wide lane in a suburban neighborhood. Her hands are on the steering wheel. She first observes a pedestrian, Megan, who's crossing the street outside of a sidewalk 100 feet in front of her car. She knows she could easily move the wheel to avoid hitting Megan without veering outside of her lane. Instead, she deliberately remains motionless and allows her car to stay on its present course. Her car hits and kills Megan a few seconds after she first noticed her. As specified so far, this example omits several details. I doubt if they're relevant, but they might be. And I think one of the problems with generalizing from philosophical examples is that they're very often under-described, so I want to add a little more detail, and so here's a little bit more. Susan is a licensed driver. She's got a spotless record. The laws, as well as the conventions of her particular jurisdiction, prohibit pedestrians from crossing the street outside of a crosswalk. Susan is annoyed that some pedestrians deliberately inconvenience drivers by requiring them to swerve when they cross streets in front of them. Susan elects not to stop or slow her car or move her wheel because she hopes to teach pedestrians in the neighborhood a lesson by scaring them. Megan actually sees the approaching car but believes that it will swerve in plenty of time, and that thus she is manifesting the very behavior that irritates Susan. Susan's surprised that Megan did not jump out of harm's way. By the time both of them realized what was happening, it was too late. Megan's last instant attempt to save herself is futile. And so that's the example. Further embellishment, by the way, of the example is available on request. So maybe you need more details. So Susan is arrested and prosecuted, let's say, for vehicular homicide. She's charged with having killed Megan while manifesting whatever degree of culpability, probably recklessness, her jurisdiction requires in order to be liable for the offense. She doesn't contest that her deliberate failure to move her wheel manifested the required culpability, which is probably the conscious disregard of a substantial and unjustifiable risk. Instead, she or her clever attorney presents the argument to show why she should not be criminally liable, and then the argument is on your handout. And so it's got 4 premises, the third of which, and a conclusion, and the third premise has 5 parts. And so there it is. If Susan is criminally liable for harming Megan, she'd be liable for an omission. Criminal liability for omission requires the breach of a duty. A person breaches a duty by omission only in the following circumstances. And then you've got a list of 5 disjuncts. When a duty is created by a special status relationship, husband, wife, or something. When a duty is created by contract. When her duty is created by statute. When she creates a peril by positive action but subsequently fails to prevent the very peril she's created, or E, when she voluntarily begins assistance but discontinues aid. And the fourth premise then is that none of those conditions apply, and therefore Susan is not criminally liable. So that's a bad argument, and I assume this argument is unsound. Of course, philosophers retain the prerogative to bite the bullet and accept an argument for panpsychism or something because they can't figure out what's wrong with it. I'm aware of anyone who thinks this argument is sound, but that's one of many possible responses someone might make. I don't take that option seriously. If, in fact, Susan shouldn't be liable for homicide as charged, I assume that the argument is not the basis on which she should be acquitted. Something else is going on. So what's unsound about it? And what I anticipated when I wrote this paper is that if you get 10 philosophers together, they'll have 6 different explanations to exactly what's wrong with it, and that might be interesting. We'll see if that's in fact so. All right, so section 2 is called positive law. Since Susan does not have a prayer of being acquitted, one might think that positive law would contain a straightforward response, an explanation of just what is unsound about the argument. But I don't think matters are so clear. In the first place, liability in cases in which the conduct of a person consists in an omission need not be liability for that omission. In its well-known statutory formulation of the so-called voluntary act requirement, the Model Penal Code specifies that, quote, liability for the commission of an offense may not be based on an omission unaccompanied by action unless the omission is expressly made sufficient by the law defining the offense, or a duty to perform the omitted act is otherwise imposed by law, unquote. More generally, the code says, liability is withheld unless, quote, it is based on conduct that includes a voluntary act. And quite a few commentators have complained about this provision because they wonder how it can conform to the principle of legality. The otherwise imposed by law part is a little worrisome in an era when we think that crimes are created by legislatures. But never mind that, that's not the problem on which I want to focus. My reservations are different. As I've contended elsewhere in the context of wondering whether possessions are acts, the precise meaning of the based on and includes relations is not altogether clear. So that statutory formulation I just read contains words like based on, the omission has to be based on an act, or the omission has to be included in an act, and I don't find those terms very clear at all. And in the commentaries, which give you some gloss on what the code means, you get examples of so-called culpability in causing. That is, situations in which defendants culpably cause their subsequent failures to act voluntarily. But they don't offer additional guidance about how the above terms should be construed. Although liability for an offense may not generally be based on an omission, unaccompanied by action, the cryptic based on relation is unexplained, and we are left at sea trying to understand whether and under what circumstances a given omission is accompanied by action. I suspect most philosophers will share a sense that imposing liability in Susan's case is consistent with these provisions, but it's hard to be sure exactly why this is so. So from now on, I'm not going to mention the based on or includes relations, and I'll simply ignore trying to reconcile what any of us think with what that general statute actually says. So one route to finding the argument to be unsound rejects premise 4. So the reason to give you a handout here is because I'm going to go back and forth referring to premises and referring especially to parts of premise 3. So one thing you could say is you reject 4 by contesting or by contending that Susan satisfies, one of the conditions listed in 3. And those are the conditions in which a duty is breached by an omission. And I would think condition C is an obvious candidate. Of course, it shouldn't be difficult to find a statute that Susan breaches. I've stipulated that she's charged with the crime of vehicular homicide, and you can always say that that statute can be committed either by persons who act or by persons who omit. To my mind, this solution involves too much contingency to provide a general resolution of the problem I want. If Susan and Megan happen to live in a jurisdiction in which no such statute could be identified, I trust no one who takes this route would switch sides and become persuaded that the argument is sound after all. But most importantly, I think, reference to a statute evades the issue from a moral point of view. So regardless of what the law may say, philosophers should still want to know what is unsound about a parallel argument designed to conclude that Susan is not morally blameworthy for killing Megan. Although the topic is notoriously controversial among moral philosophers, the conditions under which persons merit blame for their actions are the conditions under which moral philosophers think people merit blame for their omissions aren't so very different from those under which criminal law scholars think that people are blameworthy for their omissions, at least as far as I can tell. So, perhaps Susan satisfies condition D by creating the peril by positive action and then subsequently failing to prevent the very peril she's created. So maybe she satisfies D. This alternative at least doesn't rely on the fortuity of whether a statute happens to govern Susan's conduct. Nonetheless, I fail to understand how Megan's peril is created by Susan's positive act. In the most straightforward kind of case in which E applies, the defendant, A, culpably or culpably acts by, say, nudging a victim, V, into a reservoir from which V is unable to escape without A's help. Without the positive act of pushing, V would not be in the reservoir in the first place and would not need to be rescued. But Susan didn't place Megan in the road. Until she fails to turn her steering wheel, Susan is driving legally and reasonably. Surely the fact that Megan's death counterfactually depends on Susan's conduct, but for her failure to veer, Megan would not have been killed. That doesn't allow us to infer that Susan created Megan's peril. Perhaps I'm mistaken to deny that positive law identifies exactly why the argument is unsound. Reasonable minds, I'm sure, are going to differ about this matter, and in fact, they have differed. Nonetheless, I suspect that many legal philosophers are going to find some of the following options to be more intellectually satisfying. So see what you think. So now I've got section 3, the title of which is, Does Susan's Case Involve an Act or an Omission? So I believe that the two most plausible lines of response to the argument reject 1 or reject 4 by amending 3. So those are the two alternatives I take most seriously. If we reject 1 and say liability for Susan need not consist in liability for an omission, that's one alternative. Or perhaps the list of conditions in 3 is incomplete. Liability for an omission may be imposed in additional circumstances not yet specified. So which of these options to prefer? And I just want to begin by noting that whichever alternative you prefer is not going to be independent of the other. Legal philosophers who are inclined to accept 1 and conceptualize Susan's conduct as an omission will feel pressure to expand the list of circumstances in which an omission involves the breach of a duty. Thus, they are likely to reject 4 by supplementing 3. Conversely, if they are unwilling to amend the list in 3, they have some incentive not to conceptualize Susan's conduct as an omission in the first place. In short, an obvious source of the difficulty of generating an exhaustive list of the general circumstances under which omissions should be punished is due to the lack of clarity about what omissions are and whether examples such as Susan's case involve them. Different answers to the question of whether given examples do or do not impose liability for an omission are bound to produce different lists. It is far easier to answer the question of whether liability should be imposed on Susan, it should, than to answer the question of whether the imposition of liability on Susan would be for an omission. Familiar devices to distinguish actions from omissions may not be especially helpful in assessing Premise 1. Suppose omissions consist in the absence of bodily movement. So a crucial question, of course, is exactly when this absence must occur. Must it take place at the very moment that harm ensues? Well, maybe. To the extent that liability in Susan's case is difficult, its difficulty is due to the fact that Susan was not moving her body when the injury was inflicted. Yet liability seems clear nonetheless. Only a bit of progress is made if we conceptualize omissions as cases in which persons fail to move their bodies when they have a duty to do so. So Joel Feinberg says, A omits to do X when for some reason there is a moral requirement that people in the position A found himself do X. No one doubts that Susan has a duty to turn her steering wheel to avoid hitting Megan, but this obvious concession returns us to the unanswered question of exactly why this is so. Under which of the several exceptions to the general rule against liability for omissions does this concession fall? Perhaps matters can be clarified by trying to ascertain whether properties of actions that are lacked by omissions are present or absent in Susan's case. If we are skeptical that omissions can be causally efficacious, but are certain that Susan caused Megan's death and killed her, we have good reason to reject 1. But this strategy, it seems to me, employs the dubious methodological device of using a more controversial position to attempt to clarify a less controversial position. The view that omissions are causally inefficacious is at least as contentious as the categorization of Susan's conduct. So some philosophers, and you might know who I'm referring to, go so far as to say that the causal efficacy of omissions is something close to a datum that no account should contest. Megan's death counterfactually depends on Susan's omission, but her failure to turn her steering wheel may not cause death if counterfactual dependence and causation are separate concepts. If we are uncertain how to categorize Susan's conduct, and that's about premise 1, we should consider what might be said in favor of what I have called the second plausible line of argument, that rejects 4 by amending 3. The list of circumstances in which criminal liability for an omission may be imposed needs to be expanded. Does 3 indeed provide a complete list of the circumstances under which positive law imposes liability for an omission? It is sometimes alleged, by people in this room, that commentators don't offer very different answers from one another in generating lists of the circumstances under which liability for an omission attaches. So if you look at the most well-known textbooks, Wayne LaFave, Josh Dressler, G.R. Sullivan, and Andrew Simister, they offer lists that are roughly comparable. Nonetheless, you will be able to find important differences. So Simister and Sullivan, for example, include an additional circumstance that they call the continuing act doctrine. And so here's a quotation. Sometimes a defendant brings about an actus reus without mens rea, but then, while the harmful consequences continue, intentionally omits to remedy or discontinue them. In such cases, the continuing act doctrine may be applied and liability imposed without the need to find a legal duty owed by the defendant, unquote. So something like what Simister and Sullivan have in mind might seem to offer a promising solution to why the argument is unsound. Nonetheless, the continuing act doctrine, as they embellish it, is inapplicable to the case of Susan. So contrast my example with the illustration that Simister and Sullivan provide. In Fagan versus Metropolitan Police Commission, the defendant accidentally drove his car onto a policeman's foot. When he became aware of what he'd done, Fagan refused to move his car. He was convicted of assault on the ground that his refusal to remove the vehicle amounted to the continuation of the positive act of battery. As thus illustrated, three difficulties arise. First, can't we subsume all of the cases in which persons perform a continuous act under the creation of the peril condition specified in D? Obviously, Fagan drove his car onto the policeman's foot in the first place. Second, I fail to understand why Simister and Sullivan conceptualize this doctrine as an exception to the general rule that liability is not imposed for an omission. According to how I understand the proposed treatment, the continuing act doctrine turns out not to impose liability for an omission at all, but rather for an act that's alleged to be continuous. A continuous act is not an omission, it is an act that's continuous. Finally, why does Simister and Sullivan think liability under the continuing act doctrine dispenses with the need to find a legal duty breached by the defendant? All penal liability, regardless of whether it's imposed for an act or an omission, requires that a duty is breached. Either persons owe a duty not to kill others by a continuous action in every single circumstance, or only in a limited number of circumstances. That includes Susan's case. One seldom finds either variant of that new addition to premise 3 explicitly articulated in criminal law cases or commentary. That is, you often see it said that liability for omission requires the breach of a duty. You rarely see it said that liability for a positive action requires the breach of a duty, but I take that neglect simply to indicate that the truth of the claim that liability for a positive act requires the breach of a duty is just so obvious and taken for granted that people don't bother to mention it. So premise 2 doesn't state a special requirement that's applicable only to cases of omission. In any event, it's crucial to realize that the continuous act doctrine can't be applied to Susan's case, I don't think, at any rate. Unlike Fagan, Susan didn't bring about the actus reus without mens rea, but subsequently allowed it to continue. She did not simply become aware of the harmful consequence until she allegedly ceased to act. Instead, the harmful consequence, the collision that killed Megan, didn't occur at all until after Susan allegedly stopped acting. Thus, the rationale, however plausible, for regarding Fagan's conduct as consisting in a continuous act is seemingly inapplicable to my example. Okay, next section, courses of conduct. I ask again, is Susan's harmful conduct an omission? So I'm using the generic term conduct to include acts and omissions, not an unusual way of using terms, at least among criminal law scholars. So Susan engaged in conduct. Is it an act or an omission? As I've indicated, only two answers seem possible. Well, yes, Susan's conduct is an omission. No, it's not an omission, but it's a positive action. But is it really true that our choices are so restricted? According to an additional possibility to be explored, this menu of options is incomplete. Neither A nor B, yes or no, do justice to exactly how we are likely to understand what Susan has done. Instead, there's maybe another option, which is option C, and that's the option of yes and no. I think several versions of this answer might be given, two of which are as follows. First, we might say that Susan's failure to move is a special kind of omission, that is, a refraining, an intentional omission. It's a special kind of refraining that amounts to a positive act given a negative description, that is, a not moving. When we use a negative description to refer to a positive action of refraining, the conduct to which we refer has characteristics of both actions and omissions. The second version of the yes and no answer holds that Susan's conduct consists in a course of conduct that includes both an act and an omission. When this version of alternative C is placed on the table, I suspect a great many moral and legal philosophers will prefer it to any of its predecessors. In so doing, they would probably take themselves to have succeeded in identifying what is unsound about the argument. How exactly does this maneuver show the argument to be unsound? The supposition that Susan engages in a course of conduct allows us to reject 5, the conclusion that exculpates Susan. It does so by rejecting 1. Although Susan's conduct consists in both acts and omissions, she's not really liable for either, but rather for an entire course of conduct. To be sure, if you go very fine-grained, courses of conduct include omissions. Still, they're not identical to omissions. Since premise 1 is false, we have no need to reject 4 by supplementing 3. That is, we don't require an additional condition in the list of circumstances under which persons breach a duty by omission. Commentators who feel the need to do so are confused. Now, perhaps we need a separate list of the circumstances under which persons breach a duty by engaging in courses of conduct. As I've said, all penal liability, regardless of whether it's imposed for an act, an omission, a course of conduct, or whatever, requires a duty to be breached. Nonetheless, I see no reason to believe that the list should be subsumed within the list of circumstances under which persons breach a duty by omission. Commentators who believe that Susan's behavior consists in a course of conduct, but reply to the argument by supplementing 3, are guilty of much the same conceptual confusion I have brought against Semester and Sullivan. Once premise 1 is rejected, the motivation to supplement 3 is undercut. So, how do we understand courses of conduct? Well, I've got no great theory to offer here, I'm sad to say. The pressing problem is when we're warranted in conceptualizing conduct in a given example within a larger course. To what extent is our decision grounded in metaphysics, in pragmatics, or in some combination of the two? As far as I'm aware, no moral or legal philosopher has proposed a great solution to this difficulty. I'm sure I'll be hearing otherwise in a few minutes. But some of what's said, either by friends or foes of the idea of courses of conduct, seems to me to be unhelpful. Sometimes it's alleged that omissions are embedded within larger courses of conduct. Now, this statement might be literally correct. It's bound to mislead, because if you're going to use the term embed, it's equally true that actions are embedded in larger courses of conduct. A given course of conduct typically includes both acts and omissions in a very fine-grained analysis. Little is gained by calling special attention to the latter by alleging them to be embedded in the former. So why make a big deal of the fact that omissions are embedded in acts without emphasizing the converse point as well? In any event, skeptical challenges to the integrity of the concept of courses of conduct can be mounted from both directions. Might we always categorize an example as involving a course of conduct, or should we never do so? Well, the first disjunct seems highly implausible to me. I don't for a moment accept the radical position that the conduct in any example can be conceptualized as part of a larger course, so that the criteria governing our decisions to do so are wholly arbitrary. Some conceptual constraints are bound to be operative here. Still, I believe that normative criteria do most of the work, probably, in decisions whether or not to construe conduct as consisting in a course. We feel permitted to do so in order to produce results, blame or penal liability, that we endorse for independent normative reasons. If this answer is even partly correct, then you need to attend to the normative reasons for and against construing any particular example to involve a course of conduct rather than a discrete set of acts and omissions. So, although maybe legal philosophers haven't solved this problem, it doesn't follow that they've had nothing to say about it. So you can look at what, for example, Josh Dressler says. So after noting that the Model Penal Code provision that specifies that penal liability need not literally be for a voluntary act, but must be imposed for conduct that includes a voluntary act, Dressler worries that the so-called voluntary act requirement can be manipulated to include too much or too little. So he assures us that this worry can be overcome by reference to judgments of proximate causation. He says, quote, manipulation of the voluntary act requirement can be avoided if a court applies the fully stated rule of criminal responsibility. And then he puts this in italics. A person is not guilty of an offense unless her conduct, which must include a voluntary act, is the actual and proximate cause of the social harm as prescribed by the offense, unquote. If Dressler is correct to locate the solution to the problem within a theory of proximate causation, it's certain that normative rather than factual or metaphysical criteria are going to do the work. If we're confident that Susan is and ought to be criminally liable for harming Megan, but we can't figure out how to do so if we conceptualize her conduct solely as an omission, then you've got a powerful reason to regard her behavior as involving a course of conduct. In case the outcome remains in doubt, Dressler himself admits the normative status of these decisions. He says, quote, courts and juries don't discover the proximate cause of harm, they select it. The decision to attach causal responsibility for social harm to one rather than to another factor is made in a hopefully common sense matter or by application of moral intuitions, unquote. Yikes. I doubt matters are clarified by appeals to the notion of proximate causation. Still, Dressler is probably correct that normative criteria are operative to some extent in some of these cases, but you better be able to say more about the underlying common sense or moral intuitions to which Dressler refers. Appeals to a course of conduct seem appropriate when we have a verb in ordinary language that could be used to describe the activity as a whole. And in Susan's case, of course, there's no difficulty at all in finding such a verb. Susan drove. Notice I began my description of the example by specifying that Susan is driving. And I wouldn't have thought that anyone balked at that description when the additional details became available. But even though reference to ordinary language may be helpful, the presence or absence of a verb that describes the entire sequence is probably too fortuitous to get us very far. So maybe a partial solution, I believe, to improve upon a simple resort to ordinary language. Is there one? When the details of a particular case, such as Susan's case, are presented to us, does the stipulation that the complete description of what the defendant has done contains an omission, does that have any special salience? That is, should we care whether at the time Susan killed Megan that she failed to move her wheel? A prosecutor who frames an indictment would be amazed to learn, I think, that knowledgeable legal philosophers might deem it relevant that Susan was not moving her body at the precise moment of impact. Moreover, I think my conclusion here enjoys some theoretical support. The leading theorists about why omissions merit special attention in moral or legal philosophy seem inapplicable in this case. Would anyone think, for instance, that Susan should go to greater trouble to avoid hitting Megan if her conduct consists in an action than if it consists in an omission? Does the availability of fewer alternatives to avoid liability for an omission than to avoid liability for an action have any salience here? If the presence or absence of such factors makes no difference to our intuitive or common sense judgments about liability, then you've got some normative reason to conceptualize your behavior as consisting in a course of conduct rather than in a discrete number of actions and omissions. So when persons harm others by driving, I submit that we almost never care normatively or theoretically whether the driver is acting or omitting at the exact moment harm is caused. In case this reference to what we care about is thought to appeal simply to pragmatics, It may be true that we do not care about whether the driver is acting or omitting at the exact moment harm is caused because there is nothing to care about. There is such a thing as driving. And driving just is a course of conduct that includes countless actions and omissions, fine-grained within its scope. When we drive, we take our hands on and off the wheel, we move our foot from pedal to pedal, we fix our gaze in various places, and frequently do nothing at all the while we're driving. That is engaged in the course of conduct of driving. This activity serves as a paradigm case of a course of conduct. Thus, it is no coincidence that my choice of an example in which the argument is addressed involves driving a car. Other examples I could have used, cooking, I think, is an example that lends itself to a pretty similar analysis. Although we tend to conceptualize driving as a course of conduct and rarely care about whether a driver is acting or omitting at the precise moment that harm is caused, we might attach significance to the distinction in exceptional circumstances when we have reason to doubt that the person behind the wheel is driving at all. So now I want to mention the well-known case, at least well-known to some of the people in the room. This is the well-known case of Decina. So in this case, the driver underwent an epileptic seizure at the time he swerved onto the sidewalk and killed 4 children. Is the fact that the deaths were caused at the moment Decina was undergoing a seizure salient in our thinking about whether liability should be imposed? Well, sure. An affirmative answer is, of course, correct, even though Decina knew of his susceptibility to epilepsy, but failed to take medication that would have prevented his seizure. Susan was clearly driving when harm occurred. Decina arguably was not driving when harm occurred. To be sure, my judgment that Decina's case should not be conceptualized as a course of conduct is not decisive in telling us whether or not he should be liable for the deaths. I just indicate that factors that are irrelevant in typical cases, like Susan's, might be highly material in exceptional circumstances, like Decina's. If I'm right, we should resist the invitation to conceptualize Decina's conduct as consisting in a larger course of driving. Whatever position may attract us in Decina, construing Susan's case to involve a course of conduct rather than either an act or an omission seems to me to be the most plausible way to show why the argument is unsound and Susan should be liable for Megan's death. Admittedly, my solution is problematic and is not at all fully developed, and I don't pretend to have criteria to decide definitively whether every particular example should or should not be conceptualized to involve a course of conduct. So I simply challenge legal philosophers who resist my approach to identify what is unsound about the argument. So it will be interesting to see whether any particular solution to this everyday situation attracts anything like a consensus from the people in this room. Thank you.